Hello, welcome once again to Lehto's Law. I'm Steve Lehto. I'm an attorney, and today we're going to talk about how words have specific meanings, particularly the two words as, is. And I'm going to talk about a few other things along the way because I was inspired to do this because I see people misusing the term as is all the time. And I see this all over the internet. I see it in responses to my videos. I get it. People ask me questions. And the funny thing is that I've done entire videos on what as is actually means, and despite that, there are people who apparently think it's got other meanings as well. So I'm going to try to show you what as is in a legal sense actually means, and it's a very, very narrow meaning. Now, if you're buying a used car in Michigan or almost in any other state, as is has severe ramifications for you if you don't understand what it means. But beyond that, the meanings that people attribute to the phrase as is are often sketchy at best. I was inspired to do this for a variety of reasons, not the least of which is that I have had people recently arguing with me in the comments section, and I hate to keep talking about this, but when I'll do a video and I'll use a word, and people will actually chime in and go, Steve, you misused a word, as if it's a crime or something. And the funny thing is, I'll say, which word do you think I misused? And they'll tell me, and I'll go back and I don't remember the exact words I used in any video, so I actually will re-watch the video to see when I used the word. And it turns out I used the word correctly because some words have more than one meaning. And for instance, I had two people arguing with me that I misused the word recently. And when I pointed out that the dictionary definition of recently contains two or three different definitions, one of which was the one I was using, I had one of the people say, yeah, but you didn't use it the other way. And it's like, well, you realize there's some words that have like 20 or 30 definitions in the dictionary. That means that you'd never be using them correctly because I can always find the 19 you weren't using. But it's strange to me. But this whole idea that words have meanings actually eludes a lot of people. And this is also a problem. And I'm never going to go into this topic, I don't think, in full podcast mode. But I got some comments recently from some people I believe who might be sovereign citizen believers. And if you don't know what that is, look it up. There's some great videos on YouTube about it. But sovereign citizens are, among other beliefs they have, is that you don't need a driver's license. And if a police officer pulls you over and asks you for a driver's license, you simply refuse to answer any questions he asks you because you're protected by the Fifth Amendment. And then if you're ever hauled into court, you simply refuse to recognize the jurisdiction of the court. And if anybody ever does actually force you to explain yourself, you say, I wasn't driving, I was traveling. And therefore, I'm allowed to travel based on the Constitution, and you have no right to hinder my travel because it's a constitutional right, along with everything else I have. Therefore, your driver's licenses are just stupid, meaningless, and you can't enforce that law. And what's interesting is I've had people ask me and say, Steve, what right does the state have to make me get a driver's license? And I'd say, well, there's a law that says you have to. And if you believe in laws, you got to follow the laws. And I've actually had people argue with me and say, but Steve, what if I'm not driving? I'm traveling. I'm not driving. And I say to that, well, you can look it up in the Michigan Motor Vehicle Code, if you're in Michigan, for instance, at MCL 25713, that defines a driver as a person who drives or is in actual physical control of a vehicle. So if you are in physical control of a vehicle while you are traveling down the roadway, you're a driver. And you can say all you want, no, I'm not a driver, I'm a traveler. Just because you choose to use a different label than the one that the police use, the courts use, the laws use, your neighbors use, you don't always get to pick which words you use in a situation. And that's the thing. Words have specific meanings. So, otherwise I could just kill somebody and go, oh, I didn't kill them. They just ceased living. And there's no law against cessation of life as far as I know. It's either killing or murder or something, a homicide. So I don't accept your terms. I'm going to use my terms. Well, that's not how it works. So, more narrow question. What does as is mean? AS space IS. As is. Talked about it before, but the Uniform Commercial Code, which has been adopted almost everywhere, discusses how people behave and the codification of the laws surrounding the sale of goods. Okay, so if I'm selling goods, the UCC applies. And it's Article 2 that talks about the sale of goods. And in Michigan compiled laws 440 point, and then the numbers follow, which is the UCC code sections, talks about a thing called an implied warranty of merchantability, which is at 2314. And it says, unless excluded or modified, a warranty that the goods shall be merchantable is implied in a contract for their sale if the seller is a merchant with respect to goods of that kind. That's all we're talking about here for the very narrow purposes to understand what I'm talking about. That's all you need to know. By the way, I know this is bothering somebody, so I'll put it back. Sorry. Okay. So the implied warranty of merchantability is there. It's implied, but it begins by saying unless excluded or modified. So it comes right out and says this can be excluded or modified, and it tells you what section that can be found at, and that's section 2316, just 2 sections down the road from 2314. So just so you know, the implied warranty of merchantability with respect to an automobile would be that it's safe and reliable transportation. That's what most courts have defined it as. But the problem is that because they can disclaim it, most used car dealers disclaim it. But you'll also have to notice that there's something in this sentence that I just read you that's extremely important. It says, a warranty that the goods will be merchantable is implied in the contract for their sale if the seller is a merchant with respect to goods of the kind. So if you are just an individual selling a car, okay, you're not a merchant, therefore you're not giving an implied warranty of merchantability. I got an email recently from somebody who's in another state, so they got sued on a used car sale to an individual, and a court said, well, you didn't sell it as is, therefore you gave them an implied warranty of merchantability. And I explained to him that this is not a complicated matter. It's simply a matter of asking the judge to read that section where it says, if the seller is a merchant. Am I a merchant? No. Therefore, this doesn't apply to me. However, if you are a merchant and you want to disclaim the implied warranty of merchantability, you can do so under 2316 and says, among other things, unless the circumstances indicate otherwise, all implied warranties are excluded by expressions like as is, with all faults, or other language which in common understanding calls the buyer's attention to the exclusion of warranties and makes plain there is no implied warranty. So all a seller has got to do if they're a merchant to make sure something being sold with no warranty is to say, I'm selling it to you as is, and just document that as best you can. And in America, the Federal Trade Commission has the buyer's guide they mandate car dealers use to tell you whether or not you're buying it with a warranty or as is. And there's a big old box that says as is with an X mark in it. You are buying the car as is, therefore there's no warranty of merchantability. So that's the long and the short of it, as they say, with respect to buying a used car from a dealership. And if they sell it to you as is, there's no warranty. But the problem I get is a lot of people talk to me about as is and its importance in other settings. So I did a video a while back about how Sam bought the pizza car down in Georgia, or is it Florida? Someplace down there. And he got in a tussle with the people whose trademark was on the car, Big Pizza. And somebody, in fact, I've seen this now 6 or 7 times, will comment on the video and they say, he bought the car as is, that logo is his. As if buying a car as is gives you more rights. Okay? And I would respond to these people and I say, what do you mean he bought it as is? So what? Of course he bought it as is. He bought it at a vehicle auction, and I suspect that the auction, if they are considered a merchant, that they probably have a contract that you sign when you buy the wrecked vehicle at the auction that says, we're not giving you an implied warranty of merchantability here because you're buying a wrecked vehicle. Of course these vehicles are being sold as is. And I've had several people go, yeah, but he bought it as is. That means he gets it with everything. As if, like, you walk into a restaurant and I go, I want a hamburger as is, which means I get it with everything. No. All the as is means is there's no implied warranty of merchantability. What does that have to do with a trademark? Okay, nothing, 0. And I've had several people go, but he bought it as is, where is? As if the addition of 2 more words makes a difference. The funny thing is, where is, as far as I can tell, has no legal meaning. I think it's just people like the rhythm of saying as is, where is. I looked it up, and that where is just means that you, as the buyer, agree to pay to get the thing out of there if it requires transportation. So in other words, you're buying it as is, and where is, and it's yours now where it sits. Okay, I guess that's what where is means. But where is, as far as I can tell, has no actual legal meaning as far as the UCC goes. But if someone pointed out to me in a section, I'll make a comment on that. But as far as I know, as is, but as is being defined in the UCC says simply no implied warranty of merchantability, period. And now you might think, Steve, you really shouldn't be going so crazy about this because for non-lawyers to misunderstand the law, there's no problem with that. And there really isn't. There really isn't. I understand that, but the problem I have is how many lawyers I encounter who don't understand what this is. And I've actually, in court, faced an attorney who actually told a judge, Your Honor, my client disclaimed everything. Disclaimed everything. And the judge turns to me and says, Mr. Lehto, what do you have to say about that? I said, what do you mean disclaimed everything? What does that mean? I disclaim everything. I mean, what is literally that has no meaning. And I said, well, if they're talking about the as-is disclaimer, which is what they were talking about, I said that means they've disclaimed the implied warranty of merchantability. They haven't disclaimed anything else. And the attorney who was an attorney many, many years before I was, so he's a elder statesman of the law, I guess, turns and kind of puts his arms up like this. He's like, oh, fine, Mr. Lehto, what do you think my client actually gave your client despite the as-is disclaimer, which disclaims everything? And he rolls his eyes like that, and the judge is up there kind of like, I can tell the judge is getting kind of bored with my shenanigans. And I said, well, for instance, Your Honor, the defendant selling the car to my client gave my client a warranty of title. And I can see the judge's eyes light up, and I can see the opposing counsel wondering if I just invented that phrase, warranty of title. And I said, so when my client bought the car, my client didn't ever actually ask the seller, do you have clear title to this car, and are you entitled to sell it to me free and clear of all liens and encumbrances? No, they just simply said, I want to buy the car, and the seller said, we'll sell you the car. And implied in that sale is a warranty of title. You can't disclaim a warranty of title. And the opposing counsel now, who realizes that when he said my client disclaimed everything, there's a word that actually has an absolute meaning, and I had found an exception, meaning that technically he's wrong, says, what else? The dam has burst. What else is coming? I said, well, another example. My client bought the car used, and the seller filled out an odometer disclosure statement on the back of the title, maybe in the front at this time, I'm not sure which side we were using at that time, and signed it under penalty of perjury that statement of mileage was correct. I can't imagine he's claiming his client is now disclaiming that, is he? And the judge looks at the other attorney and says, are you trying to disclaim that? And now, of course, he can't say they are because I think it's a federal offense, but it's certainly a state offense. And I said, so Your Honor, there's actually a whole bundle of things that are going along here, and only one of them is disclaimed by an as-is disclaimer, and that is the implied warranty of merchantability, which is not one of our claims, ironically. I agree with them. There's no claim for that when you sold the vehicle as is, but everything else we've got. So the idea that you disclaim everything with an as is, I've actually in the last year had an attorney tell me that his client can sell stolen vehicles as is. And I said, really? I said, have you ever seen that happen in court? Like that actually hold up in court? And I could tell he hadn't even thought this through. I just said, if you sell a stolen vehicle, you're on the hook for that. And he said, no, we sold it as is. And I said, you know what as is means, right? He goes, we disclaimed all warranties. I said, can you disclaim a warranty of title? He goes, yeah, we disclaimed all warranties. I said, so you're telling me that at 440.2316, where it talks about what you can disclaim, it says that you can disclaim a warranty of title? Oh, well, it's been a while since I looked at it. Why don't you go look at it? If you have a computer in front of you, you can have it before your very eyes in about 30 seconds. It's very easy to find. I printed one out this morning, just for us, but it's very easy to find. You show me where it says you're allowed to disclaim the warranty of title, and that way you can sell stolen cars with impunity. You show that to me, and I'll go away. And he couldn't find it. And there's actually a thing, and people often ask me about being a lawyer. I've been a lawyer for 27 years. They say, Steve, is there anything about being a lawyer? I get asked a lot what I like about being a lawyer. But I've had people also ask me, they go, Steve, what do you dislike about being a lawyer? And I'll tell you, the thing I dislike about being a lawyer is there's a certain amount of intellectual dishonesty that goes on, where somebody walks into a lawyer's office and goes, hey, look, I got in trouble. I'm about to get sued, or I got sued. I did something wrong and I'm about to get sued. And the attorney looks at them and could say, boy, you screwed up. Let's see if we can't resolve this problem by straightening it out. But many attorneys will instead say, you know something? If you've got money to pay me, we'll fight them tooth and nail on every single thing here, and we'll take this all the way to the bitter end. We'll make them pay for trying to get you for what you did. And attorneys are allowed ethically. The ethics rules say if a person is accused of a crime, the defense attorney is allowed to force the prosecutor to prove every element of the crime, even if the defense attorney thinks their client's guilty. And that's considered to be what you need to have a fair legal system with respect to criminal justice, okay? Innocent until proven guilty. You can make them jump through all those hoops. But what often happens to me, because I do a lot of civil work, which is lawsuits, is I will file a lawsuit against somebody. The facts are undisputed. The law is clear, and here's what should happen. And I have a defense attorney who shows up and just starts filing stuff and asking for hearings and contesting things and objecting to things. And I've actually pulled him aside and said, why are you doing all this? And they go, I'm getting paid to do it. And I go, yeah, but when you go into court, for instance, and the judge said, well, isn't the law settled? Aren't the facts settled? Like, what are we fighting for? Shouldn't you ethically tell the judge, you know, you're right, we shouldn't be fighting? And they always get offended that I say that. They go, that might be how you'd handle it. It's not how I'd handle it. But the interesting thing is that the rules of ethics actually say that you're not supposed to go into court and argue a position that is contrary to the law. And that's what they say, well, this is the gray area, right? But I've had an attorney opposing me stand up in court, and I'll say, Your Honor, the controlling case law on this is this, and I'll cite a case. My opposing counsel will go, that is not controlling case law, Your Honor. And the judge will go, oh, then what is? And I'm all ears. If you know a more important case than the one I just gave you, let's hear it. And they go, Your Honor, I need to brief that issue. And I actually know attorneys who have admitted to me that to buy time, they were losing an argument in court. They knew they were about to get ruled against, and they actually said, Your Honor, I need to go back to my office and quickly write a brief on this. I can't remember the name of the case, but it's on my desk. And they run back to their office and start looking up cases, hoping they can find something. And then they cobble something together from another state, or they cobble together like the dissenting opinion in another case that's not controlling law, or something. And 3 or 4 weeks later, we're standing in the same courtroom, and the judge is going, I thought you said you had a controlling case on this that overruled his. Oh, no, Your Honor, that's not what I meant. With all due respect, what I was merely saying was, and the rules of ethics specifically say that if you are going to go into court and argue a position contrary to the law, you're supposed to tell the court, I am arguing a position contrary to the law because I'm asking the court to either extend, modify, or reverse existing case law. And you're allowed to ask them to do that, but you're supposed to notify them that's what you're doing. So when one attorney goes, this is controlling case law, and the other attorney goes, no, this is controlling case law, unless there's a legitimate dispute on that, one of them is probably being unethical. So I know there's probably 3 or 4 attorneys who watch my videos will disagree with me on that, and I suspect they're defense attorneys. But that's how it goes. But back to the previous issue I'm talking about here, words have specific meanings. As is has a very specific meaning. It means you're buying something with no implied warranty or merchantability if, in fact, it's sold that way. And by the way, if you're an individual and you're selling a car to somebody and you want them to sign a document saying they're buying it as is, go right ahead. But it's redundant. You probably don't need it. But if you want to do it to cover yourself, go right ahead. Some people, however, might hesitate and not want to sign such a document. But that's what as is means. Thanks for watching. Thanks for listening. Talk to you later. Bye-bye.